Garrett, thanks very much for being here.
Pleasure to be here, and good morning, everybody.
I know, as a lawyer, the question I really want to start with is, what was your experience like in front of the Supreme Court? But I'm not going to start with that question. I'm going to save it until later.
Give me time to prepare.
I'll give you time to prepare. We're going to talk about patent pools with Garrett today. And one thing I want to tell you about Garrett's background, he has had an illustrious legal career, but he is also an expert on competition law in the U.S. and foreign jurisdictions, and he represents clients routinely before the competition law authorities, the Department of Justice, the Federal Trade Commission, and others. So let me give you this scenario, Garrett, and this is not in the patent space, but you'll hopefully be able to see the analogy readily. Imagine I'm a landowner, and I want to build a highway or something like that, and I have a lot of abutters. There's a lot of people with adjacent parcels. And in order to make the highway or build the new development, whatever it is, I need to buy all of these parcels. What problems am I going to face in negotiating with the individual landowners?
I think the biggest problem you face is the last holdout. As soon as someone knows that the rights that you're making individual acquisitions for create value only if you can make an acquisition for all of them, then the last person is trying to extract that value out of their land, which may not be value at all in terms of what its value is to you, because you need to acquire all of them. In fact, this actually played out years and years ago with the Citicorp building. The Citicorp building was built on parcels that were owned individually by multiple owners, and Citicorp recognized that if they bought 9 out of the 10 parcels, that 10th person recognized that it could stop Citicorp from building its building, and therefore there was so much more value in that 10th parcel to Citicorp as opposed to the intrinsic value of the parcel. So Citicorp went through all sorts of machinations to make sure that the parcel owners thought they were dealing with different companies, that they had filed false plans with the planning board as to what to do with the property, so that nobody could really figure out that it was trying to assemble all of these 10 parcels, because the 9 of them were essentially worthless unless they could assemble the 10th.
So that's the first thing we want to keep in mind, the problem of holdout. When you're negotiating with multiple owners of property, whether it's real estate or IP, and you need all of the rights, otherwise they're not valuable, you have a serious potential problem of holdout. Garrett mentioned Citicorp. Another famous example is Walt Disney and the building of Walt Disney World in the swamp in Orlando, Florida. It's a really great story as to how the company acquired all of that property without facing the problem of holdout. Let's talk about another scenario. Let's really put this in the context of patents. Again, imagine you are a conscientious manufacturer and you know you need to license a whole host of patents. You're aware of the problem of holdout. Any other problems you're going to face in terms of how much you can pay?
So another problem in addition to holdout when you're trying to assemble all of these rights that you need in order to accomplish a single thing, whether it's building a building on multiple parcels or manufacturing a product that requires intellectual property assets from a variety of different holders, is that the more people you have to deal with and the more individually owned assets that you have to acquire, the higher the price becomes. And in the IP world, it's referred to as royalty stacking.
Yeah. So, 2 problems. Holdout, royalty stacking. You have to pay IP owner number 1, IP owner number 2. You're paying a royalty rate on each asset. And we know royalty rates can be, as we've seen in earlier classes, a percentage of net sales. So all of a sudden you're paying a percent plus a percent plus a percent plus a percent. You're just eating up your profits. So we understand now the problems of holdout and royalty stacking. Can you tell us what a patent pool is and how a patent pool solves those problems?
So patent pools have been around for hundreds of years. Perhaps the most famous one was one that was encouraged by the US government in World War II in order to amalgamate intellectual property. That was actually because of holdout and because of royalty stacking that was stopping manufacturers from making enough airplane engines to put into military aircraft. So the solution to this royalty stacking and the holdout problem is not a new one. But the modern patent pool has addressed it in far more sophisticated ways than it had been historically, particularly, as Jeff was mentioning, with respect to competition law and antitrust rules about competitors getting together and putting their assets together. But the way, in general, patent pools solve the two problems we've talked about, first of all, it solves the holdout effort, because someone who goes to a patent pool knows that it's acquiring generally the rights that it needs in a single transaction. So you're not worried about, if I do 9 deals, am I going to be able to do the 10th deal? And if I can't do the 10th deal, then the first 9 deals that I did are worthless, because I need to do all 10 to accomplish what I want to. So when these 10, if you will, patent owners put their patents together into a single license so that there's a single transaction by which I can acquire all these rights, it addresses that holdup problem and the indecision and the uncertainty that the person who needs those rights has. It knows that if I take this one single license and this one single transaction, that I don't have to worry about the holdout problem, and I can really acquire all the rights I need to accomplish the business that I want to. And it obviously addresses the royalty stacking problem, because I'm paying one royalty in one transaction for the amalgamation of rights that I need. So it really is a relatively simple solution in terms of presenting it, with a lot of complicated details underneath it.
So key points there. A patent pool ideally is collecting all the relevant patents in a particular space, so there's one-stop shopping, and you're paying a single royalty rate for access to all of those patents. Of course, we live in reality. Not every patent pool can collect all of the relevant patents, but to the extent they can collect most of them, you really reduce your transaction cost. Let's talk about the US agencies that are responsible for protecting consumers, the FTC and the DOJ. How do these agencies view patent pools? Are they pro, or are they anti?
You know, the antitrust application to intellectual property has really evolved over time. Going back into the mid-1980s, there was a real movement, particularly in the Department of Justice Antitrust Division, in terms of antitrust regulators around the world, to try to address what people were thinking of as a tension between intellectual property and antitrust. On the one hand, in intellectual property, you're given a government-granted monopoly. On the other hand, the antitrust laws say that in many circumstances, you can't use that monopoly in a variety of different ways. And so the Antitrust Division was very proactive in the early 1980s to try to figure out how to harmonize these seemingly conflicting scheme of laws, the anti-monopoly laws, but the government-granted monopoly. And so their theories have evolved over time, and they've recognized, particularly with respect to patent pools, that one that's properly run and properly constructed and addresses some of the anti-competitive effects that a patent pool can have is pro-competitive. It's pro-competitive in a lot of ways. It addresses royalty stacking. It addresses the holdout problem. It disseminates intellectual property, which competition law regulators generally think is a pro-competitive thing, because it allows more people to practice the intellectual property, thereby putting more competitors into the marketplace. It also lowers transaction costs, which again is something that the regulators think is a good thing. And it reduces litigation because people know that they can get these rights in a consensual licensing transaction rather than facing the risks of litigation, which again is another thing that regulators typically think of as being an anti-competitive tax on the system. So in a lot of ways, in the mid-'80s, they came to the conclusion that one particular patent pool that was kind of a trailblazer, that was actually initiated by Columbia as well as a couple of other companies in a very successful technology, and became probably the world's most successful licensing program ever. And it was that vehicle that, in an interactive process with the Department of Justice, came to really define the antitrust rules with respect to patent pools and the use of intellectual property.
Great. So, Gary, your answer was really fabulous. It sets me up for my next question perfectly. One thing I'll tell you about the next question before I tell you what it is, I see our lectures as building one upon another, and our guest speakers building upon another, and I want to make sure I have the proper context for our next guest speaker, Ian. So we often hear about patent pools, and the patent pool Gary just mentioned is a patent pool that is called a standard essential patent pool. Standard essential, you often see the acronym SEP, Standard Essential Patent. Garrett, what is a standard, and what is a standard essential patent?
So at the very basic level, our lives really evolve around standards in many respects. You know, you go out and you buy a lamp, and you know that whatever lamp you buy, you can take that plug and stick it into your wall outlet. And the reason for that is because there's a standard. There's a standard for the wall outlet, and there's a standard for the plug. And many of the things as you think about that you do in your normal daily life really depends on interoperability. It depends on taking that DVD disc and being able to put it into any DVD player, or any player playing any disc, or any lamp being able to plug into, and you can go on and on and on. And the reason for that is because industries develop standards, either through government-sponsored international consortium or through private industry-led consortium. But those standards, as our lives become more complicated and products become more complicated, have proliferated exponentially over the last 20 years. And in that process, where companies get together to set standards, you frequently find that either because they've actually were a mover behind the technologies that go into the standards, or because they participate in the standards and they then file patents on the standards as they're being evolved, that they end up with a patent that is necessarily infringed if you practice the standard. And that, I think, is probably a typical definition of a standard essential patent. You want to practice the standard that the industry mandates that you put into a product. And again, if you use DVD, for example, there is a DVD standard that was a private industry standard, which you can think of standards basically as a cookbook. You know, if you want to bake a cake, here's what you need to do in order to do it. An industry standard is basically the same thing. You want to build a DVD player that plays every DVD. Here's the standard, which is basically the cookbook of how you make your DVD player. And so multiple companies, as they participate in this standard setting process, end up with patents that are necessarily infringed when you put that DVD into the DVD player, and they end up with standard essential patents, which leads to the royalty stacking problem, which leads to the holdout problem, that if somebody wants to make a DVD player, they need to go around to these various companies that own these DVD standard essential patents, and so patent pools solve the problem of how you go about acquiring the intellectual property you need when your products incorporate standards.
Let me dig a little deeper on the definition of standard essential. So in our classes, we have always emphasized that when you hear the word inventions or patents, you really need to think about claims. It's the claims that matter. And when you hear the acronym Standard Essential Patent, what you should really hear is there is at least one claim in that patent that is a literal read onto the standard. What do we mean when we say a literal read onto the standard?
Basically, you can take the claim and you find the elements of those claims in the standard. You know, if your patent is a claim on this table, for example, it may recite that claim as 3 or 4 separate, as we refer to them as claim limitations or claim elements. A flat surface with 3 legs attached to the bottom of the flat surface. So that may be your patent. And if that's your patent, those are your patent claims. A surface that's flat, 3 legs attached at the bottom. So you've got 3 claim elements in that patent. Well, in order for that patent to be a standard essential patent, you'd then take those 3 claim limitations that's in that claim, you'd go to the written standard and you'd see, in order to practice that standard, do I need a flat surface? Do I need 3 legs? And do I need those 3 legs to be attached to the bottom of the flat surface? And if those claims read on the language of the cookbook or the standard, then you've got a standard essential patent.
So Garrett has already mentioned one standard that we all know, the DVD standard. There are a variety. There's a wide variety of standards that you use every day and you probably don't think about it. I want to focus on one because it is very interesting in the patent pool perspective. It's the Bluray Standard for Blu-ray discs. You probably all have at home a Blu-ray disc player, or you've probably all seen it on your computers, that little logo, little BD, that means it's the Blu-ray disc standard. It turns out that there are actually 2 patent pools that license patents that are standard essential to Blu-ray. There's the One Blue pool and the Premier BD pool. Garrett, can you help us understand why we have two pools instead of one?
Sure. I think you need to look at the motivation of patent owners in order to look at what people do with their intellectual property. And I think one of the most interesting stories of the Nortel auction that we were just talking about was that a lot of that value, at least from my perspective, and I was involved with 2 unsuccessful bids for that portfolio, a lot of the value of that portfolio was keeping it out of the hands of Google for the people who ended up with the big bid. At least that was from our perspective. I don't know whether there was agreement or not. So there are lots of ways that you can think of there being value in intellectual property. If you're a manufacturer that needs to proliferate the standard into the marketplace in order to get your products sold, one of your really strong motivations for a patent pool may just be to simply make it easy for people to license patents so there can be lots of products out there, lots of standards out there. If I'm selling Blu-ray players, I really want Hollywood to go out and make Blu-ray discs. And so I really want Hollywood to have it easy in terms of acquiring the patent rights that it needs in order to make the Blu-ray discs, because I want to make my money selling players. And I can't make my money selling players unless there are lots of discs out there. So my motivation in going into a patent pool is get the technology out into the marketplace. I really don't care the revenue that I get from it. On the other hand, you may have someone who is really more of a pure inventor. They don't really care whether there is a lot of discs out there for which player manufacturers can exploit the market. So my motivation may be to get a fair return, at least in my view, and certainly a higher return on my intellectual property than someone who is looking to get the value out of their intellectual property through product sales. And so when you put these groups of patent owners together, they all may have different motivations in forming a pool. And if you get the product sellers together, their motivation may be to keep royalty rates down, to proliferate the technology. If you get pure inventors out there, their motivation may be to keep interest rates higher. And there are lots of other decisions that intellectual property owners have to make when they go into pools, not just the value of the intellectual property or the royalty rates they're charging. And so sometimes you get different groups who own standard essential patents to a single standard who just have different motivations about their intellectual property. And because each patent pool has a single standard set terms of their license, you may find that patent pools proliferate on the same standard because there are different motivations for the different intellectual property owners as to what to do with their intellectual property.
Garrett, you've done a really great job again of setting me up for my next question, which will be my last. It's almost as if you saw these questions in advance.
No, of course not.
So the title of our course is IP for Entrepreneurs and Managers. We spend some time on IP generally. We focus a lot on patents, but are pool licensing arrangements unique to patents, or do they appear in other forms of IP?
No, they do. They appear quite frequently in copyright, for example, and the reason for that is the problems are the same. If you're putting together a series of elevator Muzak tapes, and you want to put together 50 songs that none of us ever wants to listen to, it doesn't do you a lot of good to acquire the copyright on 3 of those, because even in a short elevator ride, listening to 3 songs over and over again is enough to make you want to shoot yourself. So they'll want a long tape, and so they need multiple copyrights in order to put that tape together. And that's what kind of spurned ASCAP BMI, again with an awful lot of influence from the antitrust regulators as to how they do that. But those are amalgamation of copyrights as opposed to amalgamation of patents.
Perfect. So let me close by saying the next time you go into a club or a restaurant and you hear music playing in the background, if the owner of the establishment is conscientious, that owner has actually taken a license from ASCAP or BMI, and that license gives them the right to publicly perform those songs. That music you hear over the air, that's a public performance. It's a right protected under copyright.
I mean, even cover bands technically should be acquiring the rights for the stuff that they play from ASCAP, BMI, or other similar sources.
Garrett, thank you very much.
My pleasure.